Good evening and welcome to the last of our 3 Hare Court Commercial and Insolvency Webinars for this term. Thank you for joining us on what is obviously a very extraordinarily hot evening. We'll be taking a break in August of this Commercial Insolvency Webinar series, but we'll be returning in September. Today, my colleague Emily and I will be taking you through the subject of anti-suit injunctions with the aim of providing a practical guide to the topic. Emily having been led on a number of such cases by Silks and Chambers, and myself having recently acted for applicants in a case before the Commercial Court. Now, as anyone with experience of this topic, or who is the owner of Thomas Raphael's The Anti-Suit Injunction book, will know, it's a large subject area with a significant body of case law. And therefore, this webinar can only hope to cast a wide-angle lens over the topic to help you recognise the main practice points to note should you be involved in such a case. We'll probably be speaking for about 35 to 40 minutes, which will hopefully leave plenty of time to address questions at the end, but that shouldn't preclude you, of course, from writing them as they come to you in the chat function found at the bottom of your screen. So without further ado, we can go to the second slide, please. So I'll be taking you first through a whistle-stop tour, I should say, of the fundamental legal principles at play with anti-suit injunctions, when to make an application, the procedure involved, the evidence required, and potential alternative remedies to consider. Emily will then provide a recent case law update on the topic, touching on some of these issues, and then, as I say, we'll take time for questions at the end. So on to the first topic, legal principles. Those who have obviously done anti-suit injunction will be well familiar with this, but the first bullet point is contained there, the power that the High Court has to grant an anti-suit injunction, section 37(1) of the Senior Courts Act 1981. There's been a fairly substantial body of case law on whether other acts, such as the Arbitration Act, or indeed the High Court's inherent jurisdiction, gives the High Court the power to grant such an injunction, but that's effectively all been settled as recently by the Supreme Court, and it is just the section 37(1) that an applicant need rely on. Now, broadly, there are 2 types of anti-suit injunction: those that rely on an exclusive jurisdiction agreement or clause. And I've used the word agreement/clause there because whilst the vast majority of exclusive jurisdiction cases will be based on a contractual clause, they're not always contractual cases, and so I've therefore kept it broad and said agreement. And the second kind of case, relying on non-exclusive jurisdiction agreements or clause. I've quoted there the well-known case of Turner and Grovitt on this topic, Lord Hobhouse saying that under English law, a person has no right not to be sued in a particular forum, domestic or foreign, unless there is some specific factor which gives them that right. A contractual arbitration or exclusive jurisdiction clause will provide such a ground for seeking to invoke the right to enforce the clause. The applicant does not have to show the contractual form is the most appropriate than any other. In other words, doesn't have to show forum non-convenience. The party's contractual agreement does that for him. Now that, of course, the quote is very much talking about the first type of case on anti-suit injunction. Next slide, please. Now here I've set out the case of Axis Corporate Capital and Obster Group, where Mr. Justice Calver very recently set out the applicable legal principles. Suggests that this case and this particular section of judgment is a real copy and paste, as I have done, copy and paste template for what the principles that apply in relation to anti-suit injunctions. And I've quoted the 3 paragraphs I think are the most relevant. The first being that the burden rests upon the claimant, or I should say the applicant, to satisfy the court at a hearing that there is a high degree of probability that there is a binding applicable jurisdiction agreement. I'll come on just very briefly to elaborate on the high degree of probability test. If the claimant can do so, the court will ordinarily exercise its discretion to grant an anti-suit injunction to restrain a party from commencing or continuing with foreign proceedings in breach of the exclusive jurisdiction agreement, unless the defendant can show strong reasons why the injunction should not be granted. it follows that the burden falls at that stage upon the defendant to prove strong reasons. And again, I'll come back to touch upon what the test of strong reasons. Where an anti-suit injunction may result in material injustice to the injunction respondent, that may amount to a strong reason not to grant the injunction, but only in circumstances where the material injustice arises from a matter which is not a foreseeable consequence of the exclusive jurisdiction agreement. And he goes on to quote some potential examples of that. And then paragraph 34, where there is a non-exclusive jurisdiction agreement, so the second type of case, an anti-suit injunction will generally be granted to restrain foreign proceedings where the following three requirements are met. The foreign proceedings are vexatious, oppressive, or unconscionable. And again, I'll come back to that test. The English court is the natural forum, in other words, the most appropriate forum for the trial of the action, and it is in the interest of justice to grant the anti-suit injunction. And that third bit is really the discretionary bit of the court, that the court has to order it, even if in circumstances where the other requirements are met. Now, it should be borne in mind that these principles apply to not just anti-suit injunctions, but to anti-suit injunctions. So in circumstances where the respondent's gone off to foreign proceedings and in fact got an anti-suit injunction there, these sort of principles will still apply. But in my submission, that it'll require a very high threshold to pass to show that England is clearly the appropriate forum for the court to issue an anti-suit injunction. So turning to the high degree of probability, well, there isn't actually that much case law on what this means, presumably because it really speaks for itself. But it should be taken that it's a relatively high hurdle. It's certainly a higher hurdle than the merely arguable or realistic prospect of success tests that can be found in the CPR. In my thoughts, it typically means that one must have at least a sort of 70% chance of being correct on the meaning of the exclusive jurisdiction agreement for the court to be satisfied that it'll grant the injunction. In terms of if there is no exclusive jurisdiction agreement, and then as paragraph 34 there of the judgment says, the applicant needs to show that the foreign proceedings are vexatious, oppressive, or unconscionable. As you can imagine, the case law is again voluminous and as to what this means. But some such cases are where, for example, the respondent is trying to get another bite of the cherry in a foreign jurisdiction, so it infringes the principle of res judicata, where foreign proceedings have been brought in bad faith or with the intention to harass the applicant, or where the foreign forum was not the natural forum, where perhaps the remedial law is completely alien or onerous when compared to the natural forum being England. The terms vexatious, oppressive, and unconscionable have also been taken to be synonymous with illegitimate interferences with processes, the jurisdiction and the judgments of the High Court. Now, in terms of trying to establish strong reasons if you're the respondent as to why an anti-suit injunction shouldn't be ordered, well, again, this is a phrase that can encompass a virtually infinite set of circumstances, but the cases, again, where strong reasons have been found that where, for example, the applicant has acceded to the foreign jurisdiction, where the foreign proceedings are well advanced, particularly if the applicant has actual or constructive knowledge of the same, or where the grantee of an anti-suit injunction would expose non-parties involved in foreign litigation to inconsistent findings and litigation outcomes. So those are the sort of cases where strong reasons have been found. And I'll come on to delay, which is a particular strong reason in the case law for courts not ordering anti-suit injunctions, and something I think that Emily might be touching on in due course. So moving on to for the timing of applications. So here I've quoted from the case of Echo Bank and Tunnel, Justice Christopher Clark, as he then was, setting out when injunctive relief can be sought. So before proceedings have begun, once they've begun, within a relatively short time afterwards, when the pleadings are complete, thereafter before the trial starts, during the course of trial, or after judgment. after judgment, in essence, at any point in time. But as he says there, as each stage is reached, more will have been wasted by the abandonment of proceedings which compliance with an antecedent injunction would bring about. That being so, the longer an action continues without any attempt to restrain it, the less likely a court is to grant an injunction, and considerations of comity have greater force. So, like with most other interim applications, the relief you're seeking, the longer you wait, the less urgent it is, and therefore the more likely you are to be criticised. And the court is either to find that the respondent has a strong reason why an antecedent injunction shouldn't be granted, or ultimately the exercise of the discretion will be awarded against the applicant. Now I've put here, I'm sorry it's been slightly obscured by our logo, but at the bottom of the slide there is, if a English arbitration has been commenced, this will impact on the court's discretion. Now, that seems fairly obvious, but the reason why I've mentioned it there is that it isn't just simply the stage at which if foreign proceedings have reached. If the applicant is relying upon an exclusive jurisdiction clause that says that any disputes are to be resolved through arbitration with an English seat, but the English arbitration has actually commenced, then whether there's potentially routes that one can take with the arbitrators, in other words, under the particular arbitral rules they can apply to the arbitrators for an antecedent injunction, might also impact upon the court's discretion. In the case that I did recently in front of the Commercial Court, our arbitration panel hadn't formally been impaneled, only 2 of the arbitrators had been selected, but they were put on notice. Now, if an arbitration has in fact commenced and the arbitration tribunal have been impaneled, and a client still wishes to pursue an antecedent injunction in the High Court because it's perhaps deemed to be more authoritative and enforceable, because of course ultimately a respondent is giving a promise to the court, or is directed in the form of an order, that it should not continue to proceed with the foreign proceedings, then it's at least best to obtain the arbitrator's consent to make such an application to the High Court. Otherwise, again, an applicant will be faced with objections from the respondent that this isn't the route that should be gone down in the High Court. Moving on to the next slide. So procedure, and I think this was a bit of a learning experience for my solicitors and myself. If proceedings have not been issued, then of course a claim form particulars is required. If relating to an arbitration, then specifically an N8 claim form, arbitration claim form must be used. We found that with the Commercial Court, in order to get an application hearing, one also needed to make a separate application within the scope of the proceedings that we just issued, just for the relief of an antecedent injunction. And therefore we needed to file a separate N244CC application, of course with supporting evidence, which I'll come on to in due course. Of course, if proceedings have been issued and the remedy is for something else, and this is very much an interim remedy that's being sought, then of course an N244 application with supporting evidence is required. If made without notice ex parte, then of course must be good reason for not giving notice, and those reasons must be set out in the application itself. If one is giving notice, and I'll come back to this as a practice point, if notice is being given, then of course that should be given as soon as practical after filing, and in any event at least 3 days before the hearing. Now, in practice, without notice application should only be made where the giving of notice may defeat the purpose of the application, or the application is so urgent that even informal notice is impossible. And now, Mrs. Justice Coughlin, in my case, was rather sceptical of us having put the respondent on only informal, very late notice of the first hearing, given that foreign proceedings had only been issued in foreign jurisdiction relatively recently. So she gave her preliminary view that in circumstances where foreign proceedings are only just on foot, haven't even been served in the foreign jurisdiction, then what quite is the urgency of coming to court without giving proper notice to the other side? You know, where are realistically the foreign proceedings going to become that advanced, or even be a hearing date? And that was a compelling reason. Ultimately, the respondent provided us with undertakings, which I'll come on to talking about when I discuss alternative remedies. So she wasn't required to decide this point, but I think this is one of those particularly important practice points that one must, whilst of course there's a temptation if you find out as the applicant claimant about foreign proceedings, that the temptation is to run straight off to court and not give any notice, particularly if you have grounds to believe that the other side's conduct is being perhaps undertaken in bad faith. That still doesn't in of itself give grounds for not giving them appropriate notice to have some preparation for the hearing that you end up obtaining. If we can move on to the next slide, please. So when we're talking about anti-suit injunctions, often, of course, the respondent is out of the jurisdiction, so one needs to consider at the time of making the application whether in the application form you need to ask also for permission to serve out of the jurisdiction. Of course, those on the call will be, on this webinar, will be well familiar with serving out of the jurisdiction, but of course it's important to consider suitable alternatives, so service on English-based solicitors where the respondent has given the consent of that, or the English-based solicitors say they're on the record for the respondent, or of course if there's a contractually agreed method which stipulates that service can be at a location in England, would mean application to serve out is not required. If of course permission is required, that one needs to show the familiar test of a serious issue to be tried, there being a good arguable case that the claim falls within one of the jurisdictional gateways, and that England is clearly the appropriate forum. Now those tests is broadly, in fact, replicated really in the test that I took you through in the ASIs capital case, and that if you're likely to satisfy the court that there's a need for the anti-suit injunction, but yet the respondent is out of the jurisdiction, you're likely to satisfy these tests set out in the practice direction 6b as well. If related to an arbitration which has not been commenced, so in other words, the tribunal haven't in fact been impanelled, then CPR 62.5 applies to service out of the jurisdiction, and that creates a slightly different test, or it's not that different. And last bullet point here, it's important to remember that alternative or deemed service cannot be used to circumvent applying for permissions to serve out of the jurisdiction. And there's a wealth of case law on those points. Can we move on to the next slide, please? So what evidence does one need if you're the applicant? Well, of course, if relying on an exclusive jurisdiction clause, trite to say, but of course you need to adduce the contract in which it's found within. Often cases in relation to exclusive jurisdiction clauses either turn on the meaning of the clause itself, which Emily is going to touch upon in her case law update, or they concern whether in fact the clause itself, the contract, is binding. And so clearly, if that is what is likely, or you know that is the arguments that are going to be raised by a respondent, then of course evidence has to be put forward to show that it is a properly enforceable clause. Details of the foreign proceedings. So of course, if you're the applicant, you have found out somehow that proceedings on foot elsewhere. In my case, we found out when the other side were doing an answer to the request for an arbitration. They mentioned it in a one line. The proceedings have been issued in the Caribbean. That we felt wasn't enough to go to the High Court with, because of course we didn't know what they were about, we didn't know what relief was being sought and how far advanced the proceedings were along. And therefore we had to instruct lawyers in that foreign jurisdiction to go off to the court and actually obtain the court file, copies of it, and then of course provide us with those, and that was the claim form and the statements of case in that jurisdiction. And with that, we knew that they were absolutely in breach of the exclusive jurisdiction clause that the parties had entered into. So that's not absolutely necessary to instruct foreign lawyers to do that, but one has to think very carefully about how can I find out further details of these proceedings, enough to show A, that they're in breach of a clause, or that they are vexatious, oppressive, or unconscionable. And just one or two lines to say, we think we have grounds to believe that there are some proceedings abroad, it isn't likely to be enough. As the fourth bullet point there indicates, if you're not relying on an exclusive jurisdiction clause, then of course evidence needs to be presented that the foreign proceedings are vexatious, oppressive, or unconscionable, that the English court is the natural forum for the trial of the action, and that it's in the interest of justice to grant the antecedent injunction. If you're a respondent and opposing the antecedent injunction, then of course evidence of strong reasons as to why it should not be granted. So where, for example, the material injustice will be suffered, of course needs to be put in any witness statement in response. You can turn to the next slide, please. So alternative remedies. Now, these are important to consider because A, there may be strong reasons put forward by the respondent as to why antecedent injunction is not appropriate, and or this might go to ultimately the discretion of the court as to whether to grant the injunction or not. The most obvious alternative remedy, and as I've just indicated, the one that ultimately the respondents in my case willingly gave eventually, is a court undertaking. So rather than the injunction being an order to the respondent to stop proceedings or stop any steps being taken in the foreign proceedings and to stay them, it's of course a promise to the court that they will stay or discontinue the foreign proceedings. In terms of drafting the undertakings, it's always best for the applicant, in my view, to keep control of that and provide the language that the client is satisfied with, and that, in my view, would be the discontinuing of the foreign proceedings rather than any stay. And that's what we obtained in my case. Another potential alternative remedy is a declaration, if particularly useful if the foreign proceedings have not actually been commenced, but you have grounds to believe that they may well be. That I've quoted the test there from the Court of Appeal case for Messier, Dowd and Sabina, which is that declarations will be granted if they serve a useful purpose. Now, declaration after one has actually, the respondent has actually obtained a foreign judgment in the foreign proceedings, declaration is particularly useful if the foreign judgment is in fact in breach of an exclusive jurisdiction clause. So if someone obtains a foreign judgment in a jurisdiction and you haven't, I should say, had any involvement in that judgment, in other words, you haven't been involved in the claim, and they obtain a foreign judgment that's in breach of an exclusive jurisdiction clause, that the dispute will be tried in England, then that is actually a defence to any, pursuant to section 32(1)(a) in relation to enforcement under the Civil Jurisdiction and Judgments Act 1982. There's also potential for a declaration by an arbitrator or arbitrators pursuant to sections 30 and 31 of the 1996 Arbitration Act. And that's the power to recognise that there is an exclusive jurisdiction clause. Or of course, as I've just mentioned earlier, there is power for most of the arbitration rules, the well-known arbitral rules, such as the ICC. There is particular scope within them for the arbitrators themselves to grant what are in effect are antecedent injunction. And then lastly, I put there is applying to stay or dismiss proceedings in the foreign jurisdiction. Now, one has to be very careful about doing that. I think Emily is going to touch upon one case in where that was done. In other words, that the applicant did engage in the foreign proceedings. I would just be very cautious about that. That's certainly on the case law, not a requirement to come to court. If you do apply in a foreign jurisdiction for relief there, you may well be taken to have accepted jurisdiction there. Certainly the respondent will have a good argument before the High Court that you have. And I think in my view, it just gets messier. The better view is once you find out about the foreign proceedings, the better course of action is to just come before the High Court once you've satisfied yourself of the test that I set out from the case of Axis Capital. But perhaps we can discuss that once Emily has gone through her case law update in the question and answer sessions. So without further ado, I'll pass on to Emily.
Thank you so much, Chris. So if we could have the next slide, thank you. So as Chris said, I'm going to give an overview of 3 recent cases from the High Court. They're all from this year, so hot off the press, which demonstrate the application of some of the principles that Chris has talked you through. And what I'm going to try to do is explain my thoughts regarding the key practical learning points from each of these cases. So the first is Nigerian AGIP Exploration Limited and GEC Petroleum Development Company Limited. And this is a decision of Mr. Justice Butcher in April this year. And to give a brief overview of the background, the parties were in dispute in relation to 3 agreements, which all contained an ICC London arbitration clause. And a London-seated ICC arbitration had been ongoing since August 2018, so for quite some time. And just over a year later, the defendant brought proceedings before the Nigerian court for various declarations relating to the 3 agreements. And also they sought an injunction from the Nigerian court restraining the arbitral tribunal here from proceeding with the arbitration reference and notwithstanding the arbitration clause in the agreements. So the Nigerian court, in fact, made an ex parte order restraining the members of the ICC tribunal from continuing with the proceedings. The order was served on the arbitrators and they then suspended the arbitration proceedings pending further developments. So the claimants proceeded to apply for an anti-suit injunction from the High Court here to restrain the defendant from taking any further steps in Nigeria or indeed anywhere else. And by the time it got to Mr. Justice Butcher, an interim anti-suit injunction had already been granted. And in fact, as a result of that anti-suit injunction, the interim one, the defendant had actually filed a notice of discontinuance in the Nigerian proceedings. So what's notable about this case is really that last fact, the fact that the interim ASI had actually seemingly worked because it had prompted the defendants to actually discontinue in Nigeria. But nevertheless, the High Court didn't hesitate to make the ASI final. And the crux of Mr. Justice Butcher's reasoning is there on the slide. It's from paragraph 11. And he said, in essence, that what might perhaps be argued to be a reason why the injunction, as reformulated before him, should not be continued is, on the other hand, exactly that the Nigerian proceedings have now been discontinued and that there might be said to be no need for an injunction. But he said he was not of the view that there was no need for an injunction. And it appeared to him that there was a real risk that if there was no injunction, the defendant might take steps to interfere with the arbitration in a way which it was not entitled to do by bringing proceedings elsewhere. So among the key considerations indicating that real risk, there were quite a few, but the 3 most important ones that I've picked out were, firstly, that there was nothing in the Nigerian procedural rules that actually prevented a claimant in this situation from issuing fresh proceedings so long as they filed their notice of discontinuance before the defence had been entered. So it was a particular procedural rule in Nigeria. And so Mr. Justice Butcher said, well, I don't know that they're not necessarily going to go away and just reissue fresh proceedings, or indeed they might do something somewhere else. So essentially that was not a reason to not grant the final injunction. Secondly, it was apparent to Mr. Justice Butcher that the defendant was attempting to derail the arbitral proceedings. So, for example, they had actually petitioned for the replacement of the arbitral tribunal on grounds which appeared to Mr. Justice Butcher to be difficult to make out. So he thought it was essentially a futile attempt and that it was just a signal that they were doing everything they could to derail the tribunal proceedings. And thirdly, just touching on a point that Chris talked us through, in this case, the defendants had been asked to provide undertakings, but they'd refused to do so. So that was another reason relied upon. So in my view, that the key practical takeaway points from this decision are twofold. Firstly, it is a very good idea, as Chris indicated before, to seek undertakings from the other side before you issue your ASI application, because that way, even if they refuse to provide the undertakings, any refusal can actually be relied upon in the ASI application as being demonstrative of a real risk that they may go ahead and do exactly what we don't want them to do, which is issue foreign proceedings. And secondly, if a party reacts to the issuing of an ASI application by discontinuing their proceedings elsewhere, that doesn't necessarily mean that you should stop and not go ahead with pursuing the final injunction if you happen to already have an interim injunction, because that's not necessarily a reason for the High Court to decline to make the injunction final, because then it may still be an issue either in that foreign jurisdiction or in another one. So it's not necessarily sort of game over. So that's that case. If I can move on to the second out of my three, please. So this is a UAU and HVB. It's anonymised parties. It was a decision of Mr. Justice Calver in May of this year. And I've chosen it because it's a good example of the court's approach to the issue of delay that Chris talked us through. And so briefly, this was a dispute concerning an agreement governing participation in an oil and gas block off the shore of Equatorial Guinea. The parties had agreed to arbitrate any disputes arising from the agreement in London. The defendant commenced proceedings in Equatorial Guinea for breach of contract, and they also sought interim relief for seizure of the claimant's assets. Now, an ex parte order was made in Equatorial Guinea requiring the claimant to continue to perform the contract and also to provide certain documentation to the defendant. And what the claimant did, and this is a point that Chris touched upon and urged caution in respect of, was that the claimant appealed against that order of the court in Guinea, but did so carefully. They did so on the basis that that court, they said, had no jurisdiction to determine the dispute given the terms of the arbitration agreement. So they made it clear that they weren't submitting to jurisdiction by engaging there, but they very much were contesting jurisdiction, but they didn't hesitate to sort of step in Guinea. And in the event, their appeal was dismissed on an incorrect procedural basis. So they had to appeal again to the Supreme Court in Equatorial Guinea. And in a nutshell, the Supreme Court hadn't made their decision. They were still waiting for a decision. So they decided to go ahead and just apply for an ASI here. And it fell on Mr. Justice Calver to consider whether the fact that they had waited quite some months before issuing their ASI application amounted to a good reason not to grant an ASI. So in short, the timeline was November 2020, the foreign proceedings had been commenced. And in the meantime, the claimant had been advised by their legal representatives that there were strong grounds for challenging jurisdiction. So they tried to get the matter dealt with by way of the appeal that I mentioned. And then it was only in April of this year, after it emerged that that wasn't going to be a straightforward route, that they applied for their ASI from the English court. And in a nutshell, as I set out there on the slide, Mr. Justice Calver held that that wasn't too long, and the delay wasn't, insofar as there was delay, it wasn't fatal to the application. And the reasons relied on were that, in his view, the claimant had preserved their position and they'd challenged jurisdiction as far as it was necessary to do so, and they had reasonably believed that the jurisdiction issue could be dealt with effectively there. The claimant shouldn't be criticised for appealing the order in Guinea rather than seeking an ASI in the English court immediately. They had sought relief in a prompt manner, in his view, when it became apparent that the proceedings in Guinea were not proceeding as planned. And importantly, any waste of court time or resources that there had been as a result of the delay, in his view, were caused by the defendant's illegitimate actions, not by the claimant getting involved in the foreign jurisdiction. So the main takeaway point from this, I'd say, is that the question of delay is somewhat nuanced and it needs some careful thought. Generally speaking, as Chris pointed out, the longer you wait, in theory, the harder it will get to get your injunction. But that doesn't mean that you can't, if you think that there's a prospect of getting matters dealt with by, as in this case, appealing against a decision of the foreign court on the basis of jurisdiction and trying to get it knocked out that way, that doesn't necessarily mean that your ASI application will be unsuccessful because you've delayed. So I do caveat that, though, by echoing Chris's thoughts on the fact that you need to be extremely careful that the steps you're taking in the foreign jurisdiction don't unintentionally amount to submitting to that court's jurisdiction. And that really, that topic could be the subject of another talk. There's not time to cover it really here, but essentially, in this case, it was very clear and unequivocal that the action in the foreign jurisdiction was not a submission to the jurisdiction because they were disputing the jurisdiction. But of course, there are grey areas in terms of submitting to jurisdiction, so that would need some very careful thought before being carried out. So if I could move on to the final case now. Now, this case, Eastern Pacific Chartering and Polar Maritime Limited, it's not an ASI case, it's a case on exclusive jurisdiction clauses, which I'll refer to as EJCs. And this was a decision of Patricia Robertson QC in June of this year. And the background, very briefly, there's no need to go into the facts in detail, but it's essentially a case about the wording and construction of EJCs. And in this case, the parties had entered into a charter party in respect of the claimant's vessel. There was a exclusive jurisdiction clause that any disputes arising out of or in connection with the charter should be submitted to the exclusive jurisdiction of the High Court in England and Wales. And the words being argued over were arising out of or in connection with, particularly the in connection with part. That wasn't all that was being argued about, but that was one of the key issues. And essentially, after the defendant had re-delivered the ship to the claimant, a dispute arose over whether it was liable for the balance of the hire. So the claimant issued a claim in Gibraltar, and it actually arrested a ship which it believed was owned by the defendant in order to try to secure its claims pending their resolution. And when they issued proceedings, the defendant counterclaimed for losses suffered as a result of the alleged wrongful arrest of its vessel. So a tortious action arose. The causes of action specifically relied on were tortious interference, conversion, and inducement of a breach of contract. So a dispute arose essentially, amongst other things, as to did the tortious action or actions fall within the remit of the EJC. And the main takeaway points are summarised on the slide from the judgment. So first of all, in Miss Robertson QC's view, in connection with is naturally to be read as, if anything, wider than arising under, or variants on that phrase. She referred to the broad and common sense approach to construing these clauses, citing Fiona Trust and Privilov. which is a well-known case on the construction of these clauses. And in her view, a tort claim may be said to arise in connection with the Charter, where the claim was in a meaningful sense causatively connected with the relationship created by the Charter and the rights and obligations arising therefrom. So in this case, the steps that the claimant had taken to secure their claims under the Charter were alleged to have been tortious and to have caused the defendant loss. So the claimant took those steps in express reliance on its rights under the Charter, and if it hadn't have been for the relationship created by the Charter, those steps would never have been taken. So that was sufficient to amount to a causative nexus in this particular case. Also, it was commented that it would be consistent with a one-stop approach to resolving disputes for any damages claims arising from such steps, for them to be resolved alongside the substantive dispute in the English court, so to keep everything wrapped up together. And importantly, it was unnecessary for the tort claims to be overlapping or factually interlinked with the contract. So that is just one example referring to a particular phrase in connection with. But in my view, it's an interesting discussion there at paragraphs 33 through to 57 of the construction of EJCs, and it will serve as useful guidance to anyone who's dealing with a case where it's not entirely clear, perhaps, whether the dispute at hand falls within the scope of a particular EJC. So whether you're having to stop and think carefully, perhaps it's not as straightforward as the contractual dispute. For example, in this case, it's a sort of subsidiary or ancillary claim that's tortious in nature. Could it fall within, or does it clearly fall without? It's all going to depend on, of course, the wording that's been used in the EJC. And indeed, it will be useful for anybody that is perhaps involved in drafting an agreement that needs to contain an EJC, and you're having to contemplate what the right wording to use is. I would definitely recommend reading, it sort of runs to about 3 pages or so, that extract for some guidance on the construction principles that will be applicable. So thank you very much for listening to me drone on about these 3 cases. I hope that there have been some useful practical takeaways from them, and we will open the floor now to any questions that the audience may have, although absolutely no problem at all if it's too hot and you just want to get away from your computers, but we'll hang on for a minute in case there are any questions.
Yeah. So as I said, thank you very much, Emily. As I said at the very beginning, of course, it's the chat function to use for any questions. Giving people sort of a 1 minute, we've finished bang on time as we said we would, actually, 45 minutes. But I just want to echo what in effect Emily's echoed from my own bit of the talk about the need to, as it was, set almost traps if you're the applicant and you know you're able to rely on an exclusive jurisdiction clause. You think you have a high degree of success or a high degree of probability that you're right about it being an exclusive jurisdiction clause in your favour, to demand that undertakings are made of the respondent, because as Emily said, that refusal will provide very strong grounds for the antecedent injunction to be granted and for potentially indemnity costs to be awarded in your favour. Of course, if you're the respondent and this is an exclusive jurisdiction clause case, then of course the first port of call is to decide whether in fact it is an exclusive jurisdiction clause in favour of England. If it's not, then of course there may well be strong reasons as to why the suit shouldn't be granted. If there is, then it's going to be really a case of expectation management with the client, to say, unfortunately, notwithstanding that you might have spent a lot of money on time in the foreign proceedings, you're very likely to be at the bitter end of an anti-suit injunction order with substantial costs against you. If it's not an exclusive jurisdiction clause case, then of course the battleground is going to be whether the foreign proceedings or the respondent's actions in the foreign proceedings amount to vexatious, oppressive or unconscionable conduct. And that's likely to be, of course, the battleground that to be fought on, and to advise your clients appropriately, whether you're on the applicant side or the respondent side. Well, I've said my extra bits, and we haven't given, no one's put anything in the chat function, so I think we'll let people get off early and enjoy the weather and a cold drink. So again, thank you very much for attending this evening. We greatly appreciate it. As I said at the very beginning, we will be back, the commercial insolvency team here at 3 Hare Court will be back in September. Details will be circulated near the time on what topic we're presenting on. So at least to say thank you very much. If you haven't had your summer holidays yet, do have a fantastic time away, here or abroad, and we'll see you again soon. Thanks very much. Bye.
Thank you. Goodbye.